Okay. Ladies and gentlemen, let me call to order the October 18th, 2011 hearing. This is a hearing on an appeal of a denial of an Oregon City business license. My name is Daniel Cairns, and I am the hearings officer appointed by the city to hear this appeal. It concerns a September 15th, 2011 decision by the city denying this license, and is convened pursuant to Oregon City Municipal Code sections 5.04.080 and 090. Let me begin with a brief introduction to me and a summary of how the process hopefully will work this morning. I am an independent hearings officer. I've been appointed by the City Commission to hear this appeal. I'm not a city staff. I'm not an employee of the city. It's my job to review the record, and the record as of yesterday contained 8 items, and so it's a pretty thin record. I've reviewed that. Also, it's my job to convene this hearing, take testimony both for and against the issuance of this business license, and then to render a decision as to whether it meets the approval criteria such as they are in the city's municipal code. It's not my job to be more stringent or more lenient than these criteria allow, but rather to interpret what's in the code and decide whether the applicant has met the burden required by the code to receive a business license. Also, I am independent and impartial with regard to this application. I have no prior contacts or business dealings or family relationship with the applicant. So far, none of the adjacent property owners have weighed in, so as far as I can tell, it's just the applicant at this point. I have not viewed the property, so what I know about this case is what I've read from the record that's been compiled so far. The way the process is going to work this morning is going to be sort of akin to a land use proceeding. I'll begin with, let's see, we have, I think we might as well just begin with the applicant. As you know, the record is relatively thin in terms of explanation and justification for the decision made. So I will leave it to the applicant to explain why and how he meets the approval criteria, and then after the applicant can speak, anyone else in favor of the proposal, in favor of approval of this business license can speak. Then anyone with mutual questions or testimony can speak. Then after that, anyone who is opposed to the approval of this business license can speak. And if there's opponent testimony, I'll let the applicant have final rebuttal. After that, I will close the record and conclude the hearing, and it's my habit generally to not issue a verbal decision at the end of the hearing, but rather to take it under advisement and issue a written decision within 2 weeks of the conclusion of the hearing. If anyone would like additional time to submit written arguments, and written materials are always very useful, I can take them with me and read them several times and think about them. So if anyone has anything like that they would like additional time to formulate, you can ask for a continuance or that the record be kept open. If you have that request, we can talk about it and talk about scheduling and those sorts of things. But I would entertain continuance or more likely an open record period, so that we would not, it would be my preference to not reconvene for another hearing, but rather if there are additional written materials that people wish to submit, we can take those into the record and then the record would close. So that is the basic rundown, the summary of how the process will work this morning. The code does not provide for further appeals at the local level, so I'm left to conclude that my decision will be final, and that'll be the final decision at the city level. And what else? I guess in terms of when people want to testify, this morning's proceeding is recorded. An audio recording will become part of the record, so any comments people make will become part of that record. When you testify, do so in the order that I recited, and come up to this table in front of me. These speakers are live, and your comments will be taken up through the audio recording that way. Begin with your name and mailing address. Anyone who appears today and participates will receive in the mail a copy of my decision, and so that's the reason for the need for the address. Does anyone have any questions or requests for how a different sort of process? Is this going to work for people generally? Okay. Then with that, let's get started. As I mentioned, I've read the last word in the record is the city's denial, a September 15th, 2011 letter by City Manager Dave Frasher. So with that, I will take testimony from the applicant, Ben Watson. Is he here? Yeah. Come on down.
Ben Watson, 351 Clackamas River Drive, Oregon City. So, and you want me to start, right?
Yeah, go ahead.
All right, well, in regards to the denial letter, so there's 4 things that you could deny business for. Mm-hmm. And I feel in the letter that none of these issues were addressed at all. I think there's no evidence really of this falling under a public nuisance.
Mm-hmm. Well, why don't you maybe begin? I've read the submissions that you made that are in the record. Why don't you explain the business? Give me a clear idea of how this is going to function day to day. Who's going to participate in it? How, where will they live? How will they get there? How will they interact? How will this business work? Because this is kind of not what you'd say a real customary business in the state of Oregon.
No, it's more of a club, I would say, than a business, like a private club, and it'll be kind of ran like that. So,
is it for profit or nonprofit?
It's nonprofit. Okay.
Has it been, so you'll incorporate as a nonprofit under the Oregon Nonprofit Corporations Act?
Uh-huh,
okay.
Indeed. A medical marijuana patient, grower, caregivers, they can all it's kind of like a community. Mm-hmm. So they will be, how would you put this? The growers will come in and they will leave us with their medication, which we'll have caregiver cards for, so we can have a certain amount of medication on premises. So the patient would come in.
So you'll have, in advance, you'll have people will become members or somehow register with you?
Right. It'll be the minute they walk in, there's a window, and they'll present their card, their ID, and that's how they get in, just to verify that they're a medical marijuana patient.
Okay. So they come in and they register with you, and do they stay there, or they just register with you and then come back some other time?
They stay there, and there'll be other patients' medication there on site, and they can choose to reimburse whoever grew that medication.
Now, the growers, do they stick around, or do they just leave the material and they leave?
With myself, like on more of a consignment basis. And that's kind of how the exchange works. And they reimburse each other for...
So the growers generally won't be there. Do the growers and the patients know each other? Do they have a relationship?
No, we hope that becomes something that happens.
But it doesn't have to. So if I'm a patient, I come in, I register with you, and you have some marijuana that a grower has deposited with you, I can purchase that, or I could wait for a particular...
You can reimburse the other person. It's not a purchase per se.
So would the money go through you?
It does go through us to compensate the grower, which is legal under Oregon law.
Mm-hmm. They don't have to, the grower and the patient, they don't even have to ever meet, really. There's no requirements as far as you're concerned?
No.
Okay.
Our goal is just to make sure people have access to medication when they need it.
How do you price this?
Basically, the grower has a list of expenses and a form he has to fill out that lists all those expenses, and we calculate all that up and kind of do it by the ounce, so it varies.
So the grower dictates the price?
Yeah, within reason. We want to make sure everything's affordable.
How do you do that?
Just make sure that the growers we do accept are honest and giving us accurate expenses.
Do you ever do any testing of the material, testing for pesticides?
Yeah, we do offer that on. It's off-site in a facility in Tualatin, so that is something that we would be doing just to make sure everybody's getting.
So you would have that done?
What's that?
You would have that done, or would the patient ask?
I would have that done.
Okay.
So when the grower comes in and we evaluate the medication that he has, we would from there take a sample of that to the testing facility and test for pesticides or any other harmful things somebody might have put in there.
Okay. So you'll hold on to the material. How long would you hold on to the marijuana? However long it takes?
However long. If the grower wants it back, I guess we would give it back to him. Mm-hmm. But there's nothing, you don't have anything set as far as how long we would hold on to it.
Okay. Where was the lab? Have you got a lab already set up?
Yeah, it's out in Tualatin. The name escapes me at the minute.
Okay. So then a patient comes in and selects this marijuana and gives you the money for it. You hold on to the money until the grower returns?
Right, when all the product is all done, we would call up the grower and tell him he could come pick up the money.
Okay. So you have marijuana and money on site. It raises certain security concerns. How are you going to deal with that?
Right. We constructed, it's already in there, a solid wall with a bulletproof window, and you have to get buzzed in. You have the little window, and big time doors. Nobody can knock in. Security, full security system with cameras. All that stuff is already there. It's going to be really hard to rob the place. That place is pretty much Fort Knox.
These improvements are already in place?
They are.
Okay. Will you have any security on site? Or will you have to coordinate with the police? Or is anything like that going to happen?
We've tried to reach out to the police a few times. Haven't really got any callbacks. But we would, if we were to operate, make sure that we had a a rapport with the police department. That's definitely what we want to do. Other cities have a very good rapport with the police chief and the police, and they all have an understanding, and because it is a controversial issue at the moment. So make sure that we're all on the same side.
And in this transaction, how do you make your money?
Patient fees, to be membership fees actually, and suggested donations.
So only the patients would pay the membership fees, the growers don't?
The growers would have to as well.
Okay. What do you think the membership would be, or is there any limit to what you can handle? What do you think is the capacity, or what are you shooting for here?
Our club, we want to be conservative, so anything over 400 members, we're going to start turning away.
Okay.
There's clubs in Oregon that have over 1,000, and I feel
When you
that
say members, that includes both growers and patients?
growers, patients, caregivers,
Okay.
and that I feel that's excessive. We're not trying to have make a lot of money here. We just want to help people out.
What role will the caregivers play in this? I see a transaction between growers and patients. Caregivers would operate the same way patients would. They would come in.
Because a lot of times patients aren't able to come in, so the
Caregiver would come in.
caregivers would have to come in for them.
Okay. Would you sell anything on site besides medical marijuana?
We were thinking maybe shirts or something to maybe increase our chances of sticking around.
No.
Herbal medication, not marijuana, but just natural things.
So you have other things, potentially retail there?
Not at the moment because we need another business license for that, but that was something we do plan on doing.
Will you do anything in the course of the business to kind of monitor whether the patients or the growers, the caregivers are complying with the state Medical Marijuana Act in terms of numbers of plants and numbers of the relationship between growers and patients?
It'd be hard to control that. We can definitely control how often. Say if a patient came in one day, he picked up an ounce of medication, and the next day he came in and tried to get another ounce, that would be a big problem for us because obviously he's not doing the right thing. He's not using that as medication. We want to make sure this isn't a black market haven or anything like that.
So what would you do? I mean,
we'd probably kick him out.
So do you have set rules yet, or this? It sounds kind of ad hoc in whether you would detect this or not, and then what you would do in response to it.
If somebody was trying to do that, they would be warned. And if they were to keep trying, just as liability for our sake, we would have to make sure he's not allowed in the club anymore. So there are rules. We don't want to encourage any sort of criminal activity, which is something we'll definitely have to look out for, and we know that.
So you're not operating there yet, right? What's the situation of the property now?
It's in limbo.
So there's a building on the property.
Right.
And is it being used?
No.
Okay. Do you have a lease?
Well, it's a shared building, so there's another tanning salon right next to it. Yeah, we have a lease.
Okay, 2 tenants.
Yes, in the same
Okay.
building.
So it's pretty much ready for you to move in.
Yeah, we kind of put the cart before the horse a little bit, and we weren't expecting a business denial. So we already have a place built up and ready to go, and we didn't think we'd have a problem with the business license because this is the first city that I'm aware of that has denied a business license for this type of business. So we went ahead and did all the improvements and signed the lease, and
And then
we're
this.
sitting here, it's just empty.
Okay.
Nothing doing.
What's the term of the lease?
It's a 1-year lease. And we paid 3 months on that already.
So you're 3 months into a 1-year term.
Mm-hmm.
Do you have any people lined up to become members, or how?
A few.
So you
It's
have a notion as to what your market is.
Yeah.
Have you started taking memberships yet?
Nah, not yet. It's just kind of a word of mouth type of thing in the medical marijuana community.
Do you know what your annual fee would, or how are you going to charge for membership fees? How's that
It's going to
gonna
be $1 a day, and you could pay that all up front or every day you come in.
So you'd only pay for the day that you come in, so you're a member that day. You pay $1, and then the next day, if you don't come in, you're not a member.
You just every time you come in, just $1 fee at the door.
Okay. For everybody,
For everybody.
growers, caregivers, patients.
Yeah.
How about advertising? How will you do that?
Or not. Not. We might have, a sign on the door, but we're definitely not going to be doing any advertising except just try to do the word of mouth through the medical marijuana community, which is pretty small. So we'll probably just go that route, as opposed to big signs and pot leaves on the windows and things like that. That's not going to happen. We want to be very conservative because we want to stick around and not step on anybody's toes or anybody upset.
Have you done business like this before? What's your experience with this? How do you know this is going to fly?
Yeah, I know a few people that have club owners, and
In Oregon?
in Oregon, in various cities, and that's pretty much they all do well. There's not very much access to medical marijuana. There's a lot of people growing out there, but a lot of that is just black market. So the patients that have like legitimate diseases, injuries, they don't know how to get medical marijuana, and if they do, they have to go to the black market, and that's what we're trying to not have them do, become criminals when it's not even necessary, and support the thriving black market out there.
How many employees will you have on site?
3. About 3 or 4.
Do you have them lined up?
Yeah, it's my girlfriend and her friend, and it's pretty much a family affair.
Any of you card-carrying medical marijuana users?
Not users, caregivers, and growers.
Okay. Have you had any interaction with federal law enforcement or in connection with this operation, this business plan?
No.
Let's see. So, I guess what else do you want to tell me about the operation, the business, or anything in response to what's in the city manager's letter or what's in the city code?
In the city code, as far as that goes, in the letter, when you deny a business license, you're supposed to say, why because we fall under a public nuisance statute. You're supposed to, provide evidence as to what that is. And in that letter, we didn't see anything like that. We don't know who determined that and what basis. We have more evidence that these things aren't public nuisances. There's many that operate in Oregon with no problems whatsoever. So we just don't feel that we got a fair shake.
Okay, so you have no idea.
A lot of cities, they work with the clubs, and we would love to do that if given the opportunity. We have no idea how to go, even try to do that. It's kind of difficult to really talk to anybody or know who to talk to.
Okay. What else?
I think that's all I got.
Okay. And otherwise, you're ready to go.
Right.
Everything's set up. Okay. That's all the questions I had for the moment. Let me give us a little more thought and see if anyone else has testimony to give. Okay?
All right, thank you.
Thank you. Anyone else wish to testify in favor of the issuance of this business license? Anyone with neutral testimony? Anyone opposed to it?
Good morning. Bill Kbeisman, Garvey Schubert Bear, 121 Southwest Morrison Street, 11th floor, Portland, Oregon, 97214. And I'm the city attorney. And with me today is Lieutenant Jim Band from the Oregon City Police. And what I'm
Can you
going to
spell
do...
his last name?
B as in boy, A-N-D. Jim Band.
Like he's in the band.
Okay.
And what I'd like to do is quickly set the stage and turn it over to Lieutenant Band to talk about the determination that was made about violation of federal law and nuisance, and then come back and do a quick summary. So basically, we're here because the City Code, Section 5.04080, directs and empowers the Chief of Police, Fire Department, City Engineer, Code Compliance to investigate and examine all places of business, and to make a determination of whether any such place of business is dangerous to public health, safety, welfare, or is likely to become, or is at that time a menace or public nuisance. And if that determination is made, then the code directs us to send out the letter and request a hearing. As noted in the letter,
When you say the letter, you mean the September 15th city manager letter?
That's correct. The city made that determination, and I'll let Jim Band expand on that a little further about what the danger to public health, safety, and welfare and nuisance is.
Okay, I'd like to start. I've got a handout for you, and I could give one to Mr. Watson.
Sure.
As well.
I'll go ahead. Yeah.
You have a copy for the recorder?
Yeah.
So I'll give you my address. It's P.O. Box 3040. That's the police department, Oregon City, 97045. One thing I'd like to say, just kind of from the outset, just because I think it's relevant as I talk about our position, is that the relationship between a lot of the medical marijuana crowd and law enforcement is an awkward one. But I think that the presumption that everybody who's in law enforcement is just completely against medical marijuana and everything that has to do with it is not accurate. There are, and there are varying opinions on this, but there are certainly a lot of great care that we acknowledge is provided by people through medical marijuana. So this isn't. I want to say up front that our position just isn't inherently marijuana no, because that's not it. When we look at this topic, we're looking at this topic the same way that we look at other businesses that want to come into our city, and businesses that are in our city, and how that may or may not be a public nuisance or a menace. In fact, inside of this last year, I sat in this same chair as we had a hearing with a business in town called Cigarettes Cheaper that was selling. We had some problems with them selling tobacco to minors, and the city almost took their business license away from them, one that they'd already given them. So, this is something we do with all businesses. I want to start by turning, because I think that this is kind of a ground floor of a lot of our argument. This is a letter that's been handed out, I should say a copy of a letter from June. The U.S. Attorney for Oregon, Dwight Holton, sent this letter out. And basically it was signed by every DA in the state except for one, Michael Schrunk, and you can read the letter for it yourself. But it basically says that selling marijuana for any purpose, including as medicine, violates both federal and Oregon law and will not be tolerated. And this was signed by John Foote, who is the DA for Clackamas County. Delivery, according to Oregon law, is basically transfer of any substance, marijuana or any other drug, to another person. And Mr. Watson said himself in his statement that they do not want to encourage criminal activity in their business. When we have a letter from the U.S. Attorney saying that this violates federal law, that to him is criminal activity. And our office is sworn not just to uphold local law, state law, but also federal law, and to support.
Well, under that theory, there's no aspect of the Oregon medical marijuana program that is compliant with federal law. How do you square that?
Well, I think that there are differences between a dispensary where a third party comes in and a caregiver who is, like Mr. Watson was saying initially, where this process by which the price of marijuana is determined by reimbursing them for whatever costs they have. I mean, this is clearly a for-profit business.
Which is the grower or the
Mr. Watson's business. He's taking money to facilitate the exchange of marijuana.
You referred to? Did you refer to this operation as a dispensary?
Well, yeah, I think there's a bunch of words you could use for it, but you're basically, if I want to get marijuana, I am paying $1 to go into his business and give him money that he's going to give to the provider for marijuana. That's selling.
So this is a dispensary in your view?
Well, I don't want to attach some meaning to the word dispensary. You can call it a store. You can call it, to me it's a place where somebody goes to pay money to purchase marijuana. Mm-hmm. Whether that's a dispensary or,
an exchange. I think an exchange is what they're referring to it as.
I think that you would call it, I think that the Oregon the ORS would call it delivery. Mm-hmm. So, but again, I think that my understanding and our argument has more to do with the public nuisance aspect than there's no way that I can that I'm qualified to sit and go through the morass of what different DAs, what the federal, there's a lot of law there that I can't completely speak to. But what I can speak to is just how we interpret a letter like the one that I've handed to you.
Mm-hmm. Do you think the operation, as you've heard it explained today, and there's a description of it in the record, do you think it complies with state law?
No.
Why not?
Because, and that is purely based on what is in front of me, the same letter that I gave you, that John Foote signed saying that it violates Oregon law. That's good enough for me.
Well, I mean, this letter is not specific to this operation, so maybe if you could, I mean, this letter anticipates selling of marijuana in any form violates the law.
And maybe I could jump in here as well.
Mm-hmm.
I believe the city, this would, as described this morning, would violate Oregon law. Mm-hmm. The statutes there talk about delivery of marijuana. Mm-hmm. We believe that the consignment sales of marijuana described by the applicant violates the statutes that prohibit delivery of marijuana. There are
now. Do I understand you correctly? You say that because you see the definition of delivery says no consideration is paid for the transfer. Is that, or I don't mean to put words in your mouth, but maybe explain why you think it doesn't.
I guess
qualify under
when you're
state
saying
law.
no consideration, is that I'm not necessarily reading through the letter here. I'm talking to my understanding of what the crime of delivery of marijuana would be.
Mm-hmm.
And
Read that to you.
Sure.
Delivery means the actual, constructive, or attempted transfer from one person to another of a controlled substance.
And I think that the applicant's acceptance of marijuana for consignment and the delivery of that same material to the patient violates the statute prohibiting delivery of marijuana.
So the delivery is defined in the Medical Marijuana Act does not include the transfer of marijuana by registered identification card holder to another registry identification card holder if no consideration is paid for the transfer.
I believe the description of the business is that there is membership fees, that there is an expected donation from the patient to the grower, that even under the Medical Marijuana Act, you've got a violation there. And ultimately,
The dollar when you walk in the door.
yes,
What if they had no dollar as you walk in the door?
that's not what we have in front of us. What we have in front
Well,
of
what
us.
do you think? I mean,
Yeah.
this transfer seems to be a problem for you under the law, and the dollar strikes me as kind of a technicality here. So, is that your whole case?
I don't believe it is. I mean, it's the donation, and frankly, our case is not so much about the state law. Our case is about the federal law. The federal law, which does not provide for an exemption for exchange without consideration.
It is an absolute prohibition. So,
That's correct.
So the state law has no effect in Oregon City because of federal law.
Yeah. I mean, let me refer you to a couple cases in particular. Emerald Steel Fabricators versus Boley, 384 or 159, which involved the medical marijuana case. And, the Supreme Court sort of took it out of the marijuana situation, said, if Congress chose to prohibit anyone under the age of 21 from driving, states could not authorize anyone over the age of 16 to drive and give them a license to do so. The state law would stand as an obstacle to the accomplishment of the full purposes and objectives of Congress, keeping everyone under the age of 21 off the road, and would be preempted. So what that case tells us is that Congress has issued a federal law saying delivery can't occur, and that prevents the city from authorizing somebody to violate federal law. That's really what it comes down to, is that this applicant is coming in and saying, I have a business. My business is to violate federal law. Please give me a license. We understand our code to prevent us from doing that. And we think Emerald Steel Fabricators, there's also a more recent case from California. Obviously, the California Medical Marijuana Act is different than Oregon, called PAC versus Superior Court of Los Angeles.
Can I spell PAC?
PACK is issued on October 4th, 2011 from the California Court of Appeals. And what they say is something that authorizes individuals to engage in conduct that the federal act prohibits. They're talking about the Controlled Substance Act. Stands as an obstacle to the accomplishment and execution of the full purposes and objectives of Congress and is therefore preempted. That again is California law, but that still makes another court saying that when you have this medical marijuana situation, federal law controls. The state law may be all well and good, but ultimately, when Congress makes a law that says delivery, sale, possession of marijuana is illegal, that's what controls. That's what our city our city police department is required to enforce. So,
I might have missed something in reading the city code. If you could direct me where it provides as a basis for denial of a business permit the perceived violation of federal law.
You're correct. That what it does is the city has to make a determination that such place is dangerous to public health, safety, welfare, or is likely to become at the time a menace or public nuisance. And what Lieutenant Band will also speak to is when you have criminal activity, the nuisance, the impact on neighbors and the city.
And when you say criminal activity, you're talking purely about the violation of federal law, notwithstanding the Oregon Medical Marijuana Act.
We're talking about violation of federal criminal law, as well as state criminal laws. As I mentioned, you may have a different opinion of whether or not it violates state criminal law, but it's whether or not there's a violation of federal law.
So that's a nuisance per se?
I think it's a nuisance per se, and it's also a nuisance in fact. And
Any support for that?
And that's I'll ask Lieutenant Band to talk about his experience with things like that.
I'm not sure if it's relevant, but I think it is. I think a way of looking at that criminal activity on its own, if a federal officer,
Now, just to be clear, when you say that criminal activity, you're not referring to any sort of associated crime that might be attracted or to this,
Get
but
to
rather
that.
the violation of federal law.
specific to federal law,
Okay.
if a federal officer or if a local officer wanted to take a case before a U.S. attorney, that is a crime that would be occurring that we would be granting a license for, essentially. Something that at any point in time, any federal officer could come in at any time, arrest Mr. Watson and anybody working for him, and they could be charged federally.
And prosecuted under the Controlled Substances Act. So, in your view, I think you're getting to the nuisance per se
Yes.
argument.
Yeah, essentially the nuisance per se, the federal Congress has already made the determination that the possession, the sale, the delivery of marijuana is dangerous to public health, safety, and welfare. And that determination through the criminal law is binding on us through the business code and whether or not there's a public nuisance or a menace to the public and whether or not the public health, safety, and welfare is endangered. But even if you weren't to find a per se nuisance, there are other implications that do result in nuisances.
Maybe this is an argument for you, Mr. Kabaisman. One of the problems, and it's a foible of your code, is it's all written in the present tense. Does that matter?
It's not
I mean,
entirely
it
in
anticipates that such place of business is dangerous to the public health, safety, welfare, and it kind of goes to the place of business. I'm not really sure what to do with that.
I would point you that it's not entirely in the present tense. In 5.04080B, in the event it is determined by such officers or their agents that any such place of business is dangerous to public health, safety, welfare, or is likely to become, and I think that looks to the future. That's whether or not it's likely to become a public health dangerous to public health, safety, or welfare, or menace to or public nuisance. And it's clear that 5.04090 talk about it, the hearing on the question of whether the business license should be issued. So it really can't be only in present tense. We can't. I just don't think it makes sense when we know that there is a danger to public health, safety, or welfare that we say, all right, we got to wait for you to open before you shut you down. I think that doesn't.
Now, going back to your argument that the federal government has determined that it's dangerous to public health, safety, and welfare, has Congress actually said that? I mean, I don't think it's fair to say that every criminal statute has an implicit endangerment of public health, safety, and welfare associated with it, unless there's case law to support that.
What's the point of making something a crime if it's not that there's a danger to public health, safety, or
Well,
welfare?
the whole world of white-collar crime.
Are you telling me, well, white-collar crime isn't dangerous to the public welfare?
Well, my point is that I'm not. Sometimes you see the explicit statement by Congress, and sometimes you don't. And I'm just not aware that Congress has actually said that about this particular criminal statute.
I'll track that down, and maybe this would be a good time to request that the record be left open, and we will determine whether or not they have actually made that determination or not.
Okay. Well, before you're done, let's talk about that.
I don't know if that explicit determination has been made, but I do think that inherent in the criminal code is a determination that these activities are dangerous to the public health, safety, and welfare. .
You're not making the same argument under state law, just federal law?
I think we make it under that the state law also would find that there's a nuisance per se. I think we would say that as well under state law.
And you don't think the affirmative defense provided by the Medical Marijuana Act, what effect does that have on perceived violation of the state criminal code, I assume you're talking about?
Which affirmative defense are you?
The affirmative defense that the medical marijuana law provides, ORS 475-319. It is an affirmative defense to a criminal charge of possession or production of marijuana or any other criminal offense in which possession or production of marijuana is an element that the person charged with the defense is a person who, and then there are a couple of criteria that have to be met, but as I read the law, that's how it works. It doesn't say suddenly, it doesn't invalidate state criminal code, provides an affirmative defense.
I think the state criminal code has made a finding that the delivery and delivery and possession are a danger to public health, safety, and welfare.
How do you square that with what effect does this affirmative defense have on that legal conclusion that you just reached? I mean, are you kind of splitting a legal hair here that the affirmative defense gets you out of the criminal charge, but there's still this implicit underlying notion that every criminal offense also is an endangerment of the public health, safety, and welfare, and because this affirmative defense doesn't specifically mention that, you might get out of the criminal charge, but you won't get out of the endangerment.
I mean, it doesn't change the fact that, it's a crime. You've got an affirmative defense, but the determination of whether or not there's a danger to public health, safety, and welfare is still present.
Well, not question. I mean, you're saying per se violates, endangers public health, safety, and welfare. So, I mean, we're here to resolve that question. Is it still an open question in your mind?
No.
So the affirmative defense only applies to part of the package of problems one has under state criminal code.
And,
It sounds kind of zoning to me, though. But go ahead.
I think we may have a disagreement here, and I can make my position clear, and we.
Well, I mean, it's ambiguous what the legislature did here, is in my view. I mean, the legislature didn't, when it adopted this act, it didn't also amend the criminal code, so that if you have marijuana, it's still a crime to do that, and your card.
It's a get out of jail free card.
That's all. It gives you an affirmative defense to the criminal charge, as I read, as long as you meet all the criteria for having and using the card.
That doesn't get you to open
It's
up
still a
business.
violation of state law, as I see it. It gives you an affirmative defense, but this notion that it's only a partial affirmative defense is kind of something I hadn't thought about.
And, it's not so much that it's a partial affirmative defense. I mean, it's still an affirmative defense to the charge, but it's still a violation of the law to operate a business. And that's what
Now,
we come
to
back
operate a business, what do you mean by that? How do you, I mean, you're getting tell what do you mean by business, and what do you mean by operate?
Yeah,
so,
and we can get into the definition of business in the code, but essentially, to deliver marijuana, to possess marijuana.
But the definition of delivery, I mean, the Medical Marijuana Act has its own little exceptions to the definition of delivery.
That no fee is that no.
If you got your card, if provider and recipient have their cards, and if no consideration is paid for the transfer.
And as I understood the description that the applicant put forward, both in the today as well as in the past, a fee, there is going to be money change in hand between the grower and the patient. In addition,
But that's allowed.
Didn't you just say that no fee is paid?
For the transfer, I mean, they're allowed to reimburse for costs. I mean, under the Medical Marijuana Act.
Sure.
The vast difference, I try and compare this just from our perspective when I look at a public nuisance to other businesses that give people medicine for money. Now, Walgreens makes money making a transfer of some sort of a drug. The problem is, and you hit on it, that there's a lot of things in this law that don't completely jive. And in trying to figure out how to operate as law enforcement, it is frustrating because there's a lot of things that go unsaid or that weren't known about what would happen as a result. And those are some of the things we're going to talk about after we talk about this. The difference between an organization like this and Walgreens is that Walgreens is extremely regulated. Where the drugs come in, where they go out, there's an accounting. It's extremely well accounted for, and this is not.
But so what?
Well, so what is that? I think that when you have something that's worth a lot of money, marijuana, that a lot of people want to get their hands on, and the fact that there was no affirmative defense, or at least it doesn't seem to me that there's a portion of that allows for somebody to make money facilitating this transfer. I think that there are, from my perspective, in worrying about who is going to make sure that everybody's in compliance, making sure that we're going to get notified if people are growing outside of what they're supposed to be growing or using outside of what they're supposed to be growing. We're basically wanting some...
Let me just kind of ask you a question. So for users, for patients who grow their own, they've registered, they've got the card. Do you know in your jurisdiction who those people are?
Yeah.
So they haven't registered with you, right? Just average citizens with a card that grow their own.
There's a registry that people have to go get to have a card or to be...
But do you know who they are?
No. Nobody registers with us and says, hey, I'm growing marijuana here.
Okay, I'm sorry, go ahead.
Well, so I think where my thought was that what makes me nervous about it as somebody trying to run a police department in this town is that when we have violations, and I'll compare it to another business, there are certain bars in town who don't like calling the police when they have a fight because they've served people too many drinks or something like this. And so that creates a hazard, a nuisance, a menace, because we have kind of a dangerous, a place where a lot of fighting happens, and a group that basically has to blow the whistle on themselves to bring us up to speed. It's the same thing here. It's a model that is requiring the business to blow the whistle on its customers. And I think that the model and I think that's a different model than what I understand the last couple of years of medical marijuana to be, where this picture of a cancer patient who has a friend who's helping them out and grows just enough marijuana for that patient. Right. That to me, I don't, that's not a nuisance. That's not a problem to me if that scenario.
But it's a problem for Mr. Kabizman, per se nuisance, as I recall, as a violation of federal law and state law as well.
Well, yeah, I think that still absolutely violates federal law. But just in a context of what the nuisance is, that is not a nuisance in the way that this is a nuisance to the same degree. And that's more of a rosy picture of what I think medical marijuana, what a lot of people envisioned it to be. And some of what I'm going to talk about is the reality to us as law enforcement professionals.
I'm going to jump in for just 2 seconds. I think that's where prosecutorial and police discretion comes in. The reality is that all criminal laws can't be enforced for all violations. And the city and the police department have to prioritize what are the things that we're going to use our scarce resources on. And the individual grower who has a friend who has cancer is not something that concerns the city in the same way that a business that is facilitating the transfer of basically concentrating all that marijuana in one location and causing additional issues that Lieutenant Bannon is going to get to. So with that.
Yeah, absolutely. So the nuisance part of this is, and I kind of touched on it, like any other criminal activity that we have, we forecast based on the best indicator of future behavior is normally past behavior. Basically, if something happened once before, it could likely happen again. We have, first off, I'll say that our experience with people growing marijuana legally or allegedly legally, 2 separate armed robberies inside of the last 2 years inside of this city.
And those are against grow operations?
Yes. Licensed grow operations.
So the,
and I don't
license under the medical marijuana program?
Yes. Yeah, card holders.
Okay.
And this is, and these are not robberies in the sense of burglaries. These are people coming inside with guns, holding people hostage. In fact, the first one, there were 3 children inside. I think the girl was 11 years old, and then she had 2 little brothers who were in a closet until these guys eventually came out, and she sees her dad on the ground with a gun to his head as these guys are robbing dad of this medical marijuana grow. And then we had another one about 6 months later, exact same thing. 2 people were held hostage with a gun for medical marijuana. And what we get from drug informants is that what's even scarier than the fact that we've had 2 is that a lot of these go unreported. This happens a lot more than we know that it does because people who are growing often are out of compliance, and so they don't want to call the police because they don't, it's an uncomfortable relationship. So the underreporting causes a tremendous it's just a scary thing to have in our community, and to have a place with a sign on the wall that says, "Hey, there's a bunch of marijuana inside." That's a huge target for criminals who either want to break in at night or who are going to do something during the daytime. It's a commodity, just like anything else of value, our experience generally with medical marijuana is, and I think that if I was that guy that I talked about with cancer who had an absolutely legitimate reason to have medical marijuana, I would be very frustrated with what I think is the vast majority of people who we find who are who don't have the right intention about this law. And I'm giving this based off of numerous contacts I've had over the last few years as a police officer, police reports, search warrants that we've done. And a lot of what we see with medical marijuana in this community is not the 55-year-old cancer patient or the guy who's got chronic degenerative disc disease in his back or something. It's the 18 to 28-year-old kid who, with a wink and a nod, will tell you, I got into a car wreck when I was 16 and my ankles bugged me ever since.
But he has a card.
But he has a card. And I think it was a week ago, we had a assault that took place down at Kanema Park. A kid was going to meet a couple other kids. These kids said that the reason that they called this one particular person was because they had a medical marijuana card and they bought marijuana from them, and so they go down there to do a delivery, and it ends up leading to an assault that happened. And this is, I could go on and on about stories of people with cards who are either hanging out with, using marijuana with, or selling marijuana to people who don't have cards. In addition, a lot of people that we come into contact with who have marijuana will say, well, I'm going to get a card, but I don't have it yet.
What do you do with that?
Charge them the same way that, that we would anybody else.
That has pot.
Yeah.
Mhm.
I think that there is a part of the statute that says that if somebody has applied for a card and they haven't heard back yet or they haven't gotten their card, they're basically in compliance.
That makes your life so easy, I'll bet.
Yeah. So I guess the bottom line for us is, it is one thing when we talk about what the intent of this law was, and we've talked about this, about people who really need this. I think it's a legitimate thing, but it is so grossly abused, which we see, I would say, daily. Several times daily, our officers are running into to people who are abusing this system.
So has the situation has really changed with the adoption of this law? This was adopted by initiative in, was it 99?
Well, it's
because it's been a sleeper in Oregon for a long time, but it's not sleeping anymore. That's for sure.
no. In fact, the biggest secret that I wish got out more was this thing with the robberies, because there is so much money involved, and it turns out that both of those armed robberies that I talked about, in the final analysis, once the investigation was completed, in both examples, we had growers who started out legal and eventually started selling to people who were not providers. So they're going under the guise of selling legally and then started selling illegally. And
So you got called into both of these?
yeah,
You didn't just stumble on them,
No.
and then you investigated the basis for the grow operation, and they were illegal.
yes,
They didn't comply with the card
Yeah.
requirements.
yeah.
Okay. And what's the situation today? I suppose you seized all the material. Did you prosecute the growers?
No, not in either case.
Why?
To be honest, this is kind of, look at the discussions we're having. It's a quagmire. And for us to try and figure out
The prosecutor wouldn't take the case?
the ups and well, here's the other thing. As we're going through in the big picture, and Mr. Kabizman touched on it earlier, we had some guys who came in from Washington in the first case with guns, take a dad and his 3 kids hostage with a gun, and dad was out of compliance. We've got,
Was he way out of compliance, or
well,
because he was allowed to grow for 3 or 4 patients, and there's a certain number of plants per patient. So was this an example of the just one card and a giant grow operation, or was it he was a few plants over?
well, his violation wasn't really in terms of the number of plants. It was that too, but he was selling to people who were not
Okay.
card carrying. He was just growing marijuana under this card and then
Selling
just
it to
selling
whoever.
it to
Okay.
whoever brought him money. But in the big picture of that, we don't go after him because we've got a whole court process that we're going to have to go through, which includes having him and his daughter and the kids go to grand jury, go through a court process. In the big picture, these Measure 11 crimes that we're putting people in prison for, we're not going to, oh, by the way, we're going to charge you for, in the big picture, the violent crime is the bigger deal. And it doesn't help our relationship, over the year or two that it takes to take somebody to trial, to have your victim, and this happens a lot. There are other examples where we'll find criminal activity. If you have a rape victim and you find some meth in her purse, you're not going to charge her with the meth because
Prosecute the rape victim.
yeah. So, the other problem, like what I mentioned with the thing down in the park, more readily available marijuana is means more readily available marijuana to kids, and you can't get around that. If I would challenge anybody to go to a high school or just talk to a high school kid and ask them, is it easier for you to get a 6-pack of beer or marijuana? And they'll all laugh at you and tell you that they would get marijuana. I've yet to meet a teenage kid to tell me a different answer to that question. And so when I look at nuisance, that is something else that we're looking at. Is if medical marijuana to us was 80, if it was even 50% of people in compliance doing things the way that they were supposed to do, if it was 50%, it would be a nuisance. If it were 95% of people doing the right thing, or 90%, maybe I'd be able to sit here and say, okay, it might not be a nuisance. But I think it would stretch to say that it was 50%.
So and that's in all. I understand this is sort of an anecdotal impression, but in all of your contacts with people with pot, or is it with people with cards, or when you say 50% of what?
Of people who carry cards.
Okay.
I think they're abusing what is. I think that the spirit of medical marijuana had some good intentions, and I think there were well-intentioned people by doing it. But because it is so grossly abused, it is a nuisance to us.
Okay. So when you're saying 50%, you're saying in your contact with marijuana where a card is involved, that less than 50% of those situations comply with the card requirements.
Yeah,
Okay.
and not even close to 50.
Okay.
But, we don't always come into contact with.
The compliant card carriers.
Right.
You don't even know about them.
Right.
Or there might be lots of non-compliant card carriers that we don't get in contact with either.
I suppose even if they are just small-time non-compliant, I can understand how you wouldn't run across them. But I think that's the way it's supposed to work. Is you're not, if there isn't an exchange of information to this registry with local law enforcement, you're not supposed to really know about them. They're not supposed to be on your radar screen. They're supposed to grow their own and keep it to themselves and use it at home.
What is overwhelming, though, too, is that people are flippant about it. The people who are in possession of marijuana that we come across with, it's a joke, really. The whole smile, wink, nod. They don't even really hide the fact. They've got a card and they know, and so it makes it a lot more difficult to take it seriously. And I understand that isn't Mr. Watson's fault, but what I'm telling you is when we look at a business in town that's going to have marijuana on site that is going to deliver marijuana to people, this is the backdrop of what we look at it. All the experiences that I'm giving you, and I'm giving you the tip of the iceberg.
Mm-hmm. Well, it comports with my reading of the newspaper every morning.
Yeah. The only other thing that I was going to mention in terms of when we look at licenses, I mentioned you cigarettes cheaper. We put any liquor establishment either that wants a license or that wants to keep a license or renew a license under a microscope as well. Mm-hmm. Lawful activities that have with them some degree of unlawful activities. It's legal to go drink alcohol, but anytime we put a bar somewhere, we know we're going to have more DUIs, and that is a public nuisance. So it's not specific to this. We look at things. We look at other things the same way that we look at medical marijuana, Dottie's, that type of a business. That
What's
is.
Dottie's?
They sell sandwiches, but the majority of people go in there and gamble.
It's
Lottery
basically-
machines.
Yeah, a lottery machine fronting as a sandwich
Well,
shop.
that's the state, though.
Yeah, and we can't regulate that.
But it's just another business that we license that
Have you ever used this argument on those business license applications, or enforced when you see a spike in DUIs or ancillary criminal activity associated with the bar? So when an OLCC
Their application comes in, they comply with state and federal law. So we haven't used that argument because the business model is predicated on compliance with state and federal law. What we have here is a business model that's predicated on violating federal law.
Mm-hmm.
I will say that the cigarettes cheaper. I mentioned to you that we actually had a hearing. We were going to take their license away for violating state law.
And that you could yank their business license.
Yeah, we ended up coming up with a game plan with them. Extensive work between myself and the owner. Extensive, and that's tobacco, and that was a problem and a nuisance. And we don't have people robbing people at gunpoint for cigarettes. This is much more serious. There's a lot more people. Nobody's. We don't have gangs growing tobacco. It's just a different.
Yeah.
So.
The markup is a lot less.
Yeah.
It sounds like you've dealt with this in those contexts. What if you saw this operation as kind of the wave of the future, and say the city did nothing more than what it already has on the books, which is ignore the use, and you were forced to deal with these? What would you do in terms of working with these operators? Say that you could impose any kind of condition you wanted on this permit, but this permit would issue. What kind of conditions would you suggest, or is this just not going to an untenable situation? Because I've struggled with this myself in other contexts. Do you want these things? So like in Washington State, where they have community grow operations are lawful. Do you want them indoors where you can't see them? Or do you want them where you can see them, but also the neighbors can see them? It's a dilemma a lot of law enforcement has in Washington State. So this is the same sort of situation. Presumably, he's not creating the market, but it's out in the open business.
I think what needs to happen, the first thing that I think law enforcement collectively is going to do is, and they're already doing it, but legislatively, there's just a lot of things that need to get ferreted out. I think there needs to be...
Well, I understand that, and that's true, and I don't know how long Oregon City is going to wait before they start regulating this, but assume that's not a factor. Say the business license is your only hook.
Well, then I think that we would start moving legislatively on our local level to come up with our own regulations that were more defined.
In this instance, forget about additional legislative changes. This operation, you've heard it described, and I don't know what this building looks like, but you heard Mr. Watson describe it. Say that dispensaries are a big issue up in Washington State and in California. They're sort of an issue here, but we have these exchanges. So how as a law enforcement agency would you condition the operation as it's been described to address the issues that you see every day, or at least to try and minimize them?
And I might jump in here because one of the things that we'd condition them on is complying with federal law. I don't think ultimately that's what this issue comes down to is can we legitimately say, yes, please go ahead, do your business that we know violates the law. And it's hard to craft conditions that would allow this business to go forward that would not be the city authorizing this business to violate law. And that's really, if you look at the PAC case, what happened...
Well, but you two are arguing two different sides, right? The lieutenant is talking about what he sees on the street and the ancillary criminal activity, which is, in his mind, is a nuisance. I understand your technical legal argument, and it is what it is. But I'm more concerned with lieutenant's issues.
But I think it goes beyond that, because I think if this business license came in and they said, hey, look, here's what we want to do to sort of try to get a handle on this. And what we're going to do is say, you can only have on consignment no more than 16 ounces at a time, that you can only limit the membership to 100 people, that the doors have to be so thick that the hours of operation that you can have consignment. What I'd tell Lieutenant Band is, I don't know if we can do that, because what we're doing is saying,
Hey, if we put them on conditions of a business permit, I mean, you might be right. I mean, maybe this will get to the Supreme Court and they'll say you lack the authority, it's unconstitutional. But, I don't know about that. I mean,
and it's not unconstitutional. And this, again, the Pack versus Superior Court of Los Angeles was essentially the city of Long Beach trying to do this under the California Medical Marijuana Act. And what they said is, hey, we're getting these dispensaries around here. We've got these issues with them. Let's try to get some control. They tried to approach it legislatively and said, if you're going to open up a marijuana dispensary, you've got to meet these sticks. You got to do these various things.
they imposed additional local requirements on dispensaries that were allowed by state law.
Exactly. Somebody challenged that and said, you can't do that.
State law doesn't give you the authority to add
to do things that are in violation of federal law, and that's exactly what the court in California said. You can't do that. A law that authorizes individuals to engage in conduct that the federal act forbids stands as an obstacle to the accomplishment and execution of the full purposes and objectives of the Congress. Whether you and I think that's a great idea or not, that's what the law says, is we can't do it.
How does the city regulate this from a land use perspective?
We don't. There's no recognition
plan?
of marijuana, medical marijuana businesses in the city zoning code. I'm trying to think if there's a prohibition on businesses, uses that violate law. I'm not certain I know of it. It probably, to the extent there wasn't a violation of federal or state law, it'd probably be a commercial use. It would be, you could do it in a commercial district, and I assume this is a commercial district. We haven't even looked at that, but I don't think there's a zoning implication here.
It's next to a tanning salon, so you might have more problems.
I'm not going to go there. But ultimately, and we've spent some time talking about the impacts of marijuana and the armed robberies and the other impacts. It's not a reflection on the applicant. Frankly, we don't know that much about the applicant other than what he submitted, and we're certainly what he's bringing forward is a good attempt to meet the Medical Marijuana Act. But the problem that we have gets back to what Lieutenant Band was talking about, sort of the spirit of the medical marijuana law, and written into really the letter is you have the grower who has their contacts who that there's a relatively limited presence of marijuana in connections.
Right.
And what this business is trying to do is drive a wedge into that and expand what that spirit and idea is, which results in significant concentrations of marijuana and that type of activity, which is the type of thing that leads to greater issues. One
of the problems, and I think that your question actually touched on it, is the problem is, what do we do if a license was granted? Is what can we do? Once a license is granted, this is other than telling our narcotics officers, if you hear anything, let us know. Because eventually, anybody, I don't care what the drug is, when somebody finally gets in trouble for being out of compliance, they're going to offer who is above them for consideration. I mean, that's how we bust drug dealers. Short of sitting and waiting to clean up the mess, we have no real control. At the outset of this, I talked about one of the inherent problems with this is this awkward relationship between law enforcement and the medical marijuana crowd. If this did go through, I don't expect that the police department's going to get phone calls from from this or any like business, every time somebody's out of compliance, I think it'd be crazy to think we're going to get any phone calls. And so the problem is our way of dealing with it. We can't just single people out and start harassing people and stopping every car that leaves there, and we can't do that.
Okay.
There's no real mechanism other than sitting and waiting.
See, I guess that's what I was getting at in my question to you, that there may be some like reporting or clearing kind of background check process that could be required for membership here, something like that. Because I understand that you don't really have access to their business records other than to sit in a car outside this establishment and watch.
A background process is, there are cops who end up getting hired, and we do a background unlike just about anybody, and things don't get unearthed. And there's a lot of criminal activity that people have just never been caught for. So that is, a background doesn't do us any good. A camera does us very little. Camera very rarely can identify a suspect. We have to find a suspect, and then we go, yeah, you're the guy in the video. So there's a lot of things that seem like they would help or seem like but they really don't.
Because I don't know how often people in the legislature talk about this act, but the day is coming when they're going to have to amend the Medical Marijuana Act to deal with these problems. The way it was originally envisioned, I think you've correctly characterized, but certainly it's evolving into there is a distribution aspect of this, and so the dispensaries are and the collective grow operations. It's very hard to keep this going when it's just a one-on-one or a small up to 3 people type relationship. And so this has been the trend in all the states that allow this. And so you might be faced with having to do this someday when the legislature in their infinite wisdom allows and regulates dispensaries.
Yeah. And when that day comes, hopefully the legislature will deal with some of this. Maybe they will, maybe they won't. But in the meantime, what we've got is somebody essentially trying, in an admirable spirit of entrepreneurship, trying to start a business of a dispensary under regulations that don't really allow dispensaries.
You mean the Medical Marijuana Act? Well, looking through this, and what if what Mr. Watson described was kind of way out of whack with the Medical Marijuana Act, and so if he received a business license, then as soon as he starts operating, he'd be subject to prosecution under the criminal laws. So I guess that's sort of a rhetorical statement. People operate dispensaries in Washington State, and I just don't see how they can do it and comply with the requirements. They even regulate dispensaries, and it's not. And here they aren't specifically authorized. They're not prohibited. This isn't a classic dispensary type what he's described in my mind, because and that's what's evolved in Oregon are these exchanges. Because they're, you can cobble together the pieces, and technically it doesn't violate any of the elements of the Medical Marijuana Act so as to disqualify the participants from the affirmative defense they would get, maybe. And you're right, I'm not aware of police, law enforcement agencies that look at this because it is sort of such a mess and prosecutors won't touch it.
Certainly, we have too much more to add. I would note 2 things. One, I meant to mention at the beginning, and I ident and then keeping the record open. So, I don't think we need a very long record period to go track down the Controlled Substances Act and the local, the state regulations as well. So, no more than a week, but even less than
Well,
that. is probably
to be
good.
fair, also, I don't know how much verbal communication went on between the city and Mr. Watson, but I got to say the city manager's letter was a little thin in explanation, and I think the explanation was articulated today, so maybe Mr. Watson's hearing all of this for the first time. And so I think he's entitled to respond to it.
Certainly have no objection to that. The other piece you mentioned about the final decision that and this is sort of procedural, sort of stepping
Sure.
away from the substance for a minute. Under 5.04110, they have, upon application being made, any investigation required by the chapter be made having been satisfactory completement without a determination, or if such a determination has been so made, and if the city commission finds that such determination is not supported by substantial evidence, if the fee is paid here and provided, the license shall be issued by the city recorder. So essentially, 5.04110 appears to contemplate that the city commission sticks
Well, I
its
wasn't
nose
sure
in
about
his-
that.
And
So what do
frankly,
you think? Is this appealable to the city commission? Did you write this?
I think that was actually when a prior city attorney may have been involved.
Well, he should have been fired. So anyhow.
So I don't know what to make of that because I'm not certain if the city commission wants to weigh in on it or not. And maybe what
Well, I don't think that really,
yeah.
between us chickens, I don't think we really have to care what the city commission wants.
Well, as
Because
my client, I may have to, but that's
that's your burden to bear.
Yeah.
I came into this morning thinking that there may be a way to city commission, but
I guess let me go back and maybe in that open record period we'll also put together our view of what the process is in terms of whether there's an appeal, whether it automatically goes to the city commission, or whether you're the final decision.
Mm-hmm.
But ultimately you make a decision. And
and I also feel that a lot of it, I never felt that more process is a bad thing for anyone. This, as far as I know, is the first time it's ever happened in Oregon City. I'm not aware of this being I'm not aware of any other business license cases in this state. I always have to wonder. Well, anyhow, it does come up in Washington periodically. Business license as the last vestige of regulatory authority over these things for some strange reason, but being the first time. And especially what the lieutenant has articulated, are a number of important kind of policy issues, community issues, and for the record, I do not live in Oregon City. So I could be persuaded either way. I mean, it has important policy issues. When I think, is there a role for the elected governing body to play? It is if there are important policy issues at stake, and over time, there are less and less of those in the land use context. So it's understandable and in my view, appropriate for governing bodies to get out of the appeals circuit on land use. But it's not my view that we're there yet on this.
Yeah. And I agree, and I don't have any great wisdom for you at this point, or wisdom or not, unwisdom.
Well, that's not your job to give me wisdom. You give me your view.
Yeah.
And I understand you represent the city commission in this. So you'll just have to figure that out and express your view during this open record period procedure. Are you tracking this, Mr. Watson? That procedurally, where does this go? The code doesn't really anticipate this sort of situation. And so is this decision appealable to the city commission somehow, or otherwise you're left basically to appeal to a circuit court through a writ review, which, it's you're before a judge, and the judge kind of looks at the law, and any judges don't like to see this either, because it is so fraught with all these policy issues. that are relevant and unique to the local community setting.
With that, I'll wait to hear your determination of how long. Maybe Mr. Watson has a view of how long to keep the record.
But you need
open.
a week?
A week, you would be fine.
Okay.
Lesser would be okay, but
Okay.
it's just a good round number that I'm used to.
Okay, and you said, let's see, anything else? If you might give me the case sites for the,
Sure.
I'm aware of the Emerald Steel Fabricators case, but the PAC versus
PAC
Los
versus
Angeles
Superior Court. I don't have a site. It was issued on October 4th, and what I
Okay,
can do
I might be able to find that.
is give you a copy of it. I can
That
also.
Yeah, you can.
And I don't have another one for the recorder or for.
Well, the record's open, and you could shoot her a copy.
All right, I will shoot both Ms. Watson and you.
Thanks.
Thank you for your time.
Thank you. Mr. Watson, why don't you come on down? Or is there anyone else who wishes to testify on this matter? For, against, or neutral? Okay. So you have the right of rebuttal. You can do that. You can do that now, and you might want to take some time to off the top of your head. But also, the record's going to be left open for a submission of written materials, and over time you can think about and maybe put together something in writing as well. And there's this procedural issue. I don't know if you have an opinion about that. Part of it's based on the code, and the code, you look at the procedures that we're dealing with here, and this, it does talk about that there might be a role for the city commission to play, but how it gets there is not entirely clear. So I don't know if you have a preference for if this would be appealed to the circuit court judge versus your local elected city commission or not.
Yeah, I have no idea.
So anyhow, go ahead. You have the right to respond to what you've heard today, and also the right to supplement that in writing afterwards.
I definitely agree with the lieutenant. There's a lot of problems with the medical marijuana the way it is right now, and the people abusing it. People abuse it left and right. That's kind of the wild, wild west out there. Like, it's not hard to get cards anymore, and a lot of people use it as fronts for illegal activity. Mm-hmm. But there's also a certain portion of us that we want to separate ourselves from all this mess. Having a club, it's inherent. There's some risks involved, and the people that choose to be a club member, their name's going to be on a piece of paper, and they know that should anything happen, federal intervention, their name's going to be out there. So the type of people that you see coming to these places, are the people that are willing to go on record saying, yeah, I'm here, I want to do this the legal way. I don't want to go through the black market anymore. These are the people that we're looking for. The average age of a medical marijuana patient is 57 years old. This isn't like we're definitely looking for the family type of people. There's a certain, there's a type of person we're looking for to be in a club. We don't want to associate ourselves with all that, all the crazy medical marijuana illegal stuff going on out there. I wish there was a way to bridge the gap between this awkwardness that is out there. But I wish we could do something like that. I'll keep trying. Yeah, I just wanted to agree with a lot of what they said. It's true. It definitely needs some legislation. I just want everybody to know that we're here for the right reasons, and every one of these clubs that pops up, it hurts the black market a little bit because all those medical marijuana patients don't have to go to the black market guy down the street. They can just come to a safe place, secure place. They don't have to worry about their safety. So, that's pretty much all I have.
Okay. Okay. With that, I would like to deal with the procedural request that was made to keep the record open. The city's asked for a week, and to supplement the record, and I'll do that. So this is October 18th. So a week would be October 25th. And how about you have a week to respond to what they submit? And you could also respond to more fully, if you wish, to what you heard today. They covered a lot of issues that aren't that germane to you and your business, but yet are a big part of the city's argument that this is going to be a nuisance and a menace and a hazard to the public health and safety and welfare for a number of reasons that may be specific to you, and some that may be symptomatic of how medical marijuana actually operates in this state. You could write a lot on that topic, I would think. You may or may not want to. One other issue that I wanted to ask while the city was still up here, and Mr. Kabizman, you might mention this in your written submission. Who normally, if this permit had been approved, who normally approves the permit? I guess who raise your hand if you know the answer to this question.
Finance manager was
The business license itself?
Yeah.
Um,
Would that be you?
No. Well, according to the code, it says that it's issued by the city recorder's office, but the finance department, they are the ones that issue the business license.
Okay.
We have a finance staff person who is the business license specialist, Esther Beverly, and
Okay.
but it's the finance department that
Okay,
issues
so Ms.
the
Beverly is the one who signs these things. Do you think Ms. Beverly would be subject to federal prosecution for permitting something that's illegal under federal law? Theoretically, I've read what the U.S. Attorney has said about the likelihood of prosecution, but it is a legitimate fear among a lot of local governments, maybe not in this state, but in other states, California, I think, and certainly Washington. Local government involvement in the permitting of these facilities, aside from any oaths that public officials take when they assume their offices. Well, it did today.
And now it has.
Okay. So that's what I'm inclined to do. Leave the record open as I explained. Does that make sense to you? Does that seem fair?
Yeah,
Okay.
absolutely.
Okay. Anything else before I conclude today's hearing from anyone? Okay, with that, I will conclude the hearing. I'll leave the record open 1 week for the city to submit additional argument and documentation, and then a week after that until it would close on the first Tuesday in November, which would be the 1st of November, for Mr. Watson to respond to everything that was said today and whatever additional the city submits during its open record period. And at that point, the record will close. I'll take all that and issue a written decision probably within 2 weeks of when that record closes. Okay?
Cool.
All right. With that, I'll conclude today's hearing. Thank you very much
Thank you.
for all of you taking the time.